Yes.
Excellent. Got it.
Hi, I'm Dr. Randy Bach. Today is September 20, 2023, and I'm honored to have Professor Barak Richman with us. Tell us a little bit about yourself, your recent forays, and what your concentrations are in the realm of, say, competition within healthcare.
Well, Randy, first of all, thanks for having me on again. It's always fun to talk to you about healthcare and about all things related. So by way of introduction, I'm an economist. I'm a lawyer. I am not a physician. My interest in health policy, you might say, has been heavily shaped by my identity as an economist and my vocational interest as an antitrust attorney. My first significant work in health policy came through the antitrust lens, trying to understand why it's been a real problem to stop hospital mergers, even those that created monopolies. I've often looked at healthcare, especially Medicaid policy, through the lens of behavioralism and the social determinants of health. And in particular, a lot of my recent writing has expressed a lot of alarm at the rise of conglomerate hospital systems, and how these hospital monopolies are not only charging monopoly prices, as all monopolists do, but also are really changing the way healthcare is being delivered, with mostly and almost uniformly detrimental results.
So what are those detrimental results? How does it play out on the landscape? I was reading your Wall Street Journal co-authored piece on the Indian American family or Hindu American family who wanted to have care, but across state lines. Oh my God! But in other veins, what are the tweaks we could apply to the system? What are the likelihoods of those, and what are the impediments currently? And what would you say is the kind of the way it plays out in the general household of an American?
Yeah. So I mean, thanks for reading that Wall Street Journal piece. I like it a great deal. The story there is that you had a cancer patient who was living in Ithaca, New York, and her primary oncologist was at Dana-Farber in Massachusetts, in Boston. And for much of her direct care pre-pandemic, she went to Boston for some intensive treatment, and for some follow-up care during the pandemic, she was able to converse with her physicians through telemedicine. That was only because, as you probably recall, during the pandemic, there were all sorts of waivers that allowed telemedicine to replace in-person care. The problem with getting telemedicine after the pandemic was that some of those waivers had expired, and Ithaca, New York, and Boston, Massachusetts are in different states, and legally the problem was that her Massachusetts provider did not have authority to provide care virtually in New York. So instead, she had to drive 3 hours across the state line, sat in a parking lot somewhere in Massachusetts, in Western Massachusetts, and got telemedicine. This is a legal barrier that doesn't make any sense. Virtual medicine cannot replace all sorts of in-person medicine, but it can be a real convenience for a lot of people. And we have a licensure regime that's still controlled by state medical boards. And it has all sorts of rigidities. It has all sorts of fiefdoms. And we simply said that, look, what we really want is we want the powerhouses in New York and the powerhouses in Boston to compete with each other on a regional basis. And having a limitation on telemedicine impedes that meaningful competition. So a lot of what I do, not just through the antitrust laws, is I look at the law, especially the law as it relates to the delivery of healthcare, and I try to figure out how laws can be tweaked to enhance competition and improve outcomes. And this rule on telemedicine is one of them that really impedes competition.
Yeah, seems pretty simple, but like anything else, you're going to get the people who have already climbed up the ladder pull the ladder up.
I mean, part of the licensure regime, one of the problems of the licensure regime is that it is, in fact, for lack of a better word, it's controlled by a cartel. I mean, the doctors in Massachusetts decide who in Massachusetts can practice. The doctors in New York can decide who can practice in New York. And even a very well credentialed oncologist in Massachusetts still needs to get some kind of authority from the New York Medical Board in order to treat New York patients.
Right.
And those are subject to the antitrust laws, and there needs to be some kind of rationale behind that. But it's an administrative fiefdom that creates impediments.
Right. So you are an economist and a lawyer. The economist part, I don't know. I assume you have a PhD and you're a professor at Duke, whatever. You could probably transfer and do your economy stuff at Stanford or University of Montana or Singapore. But the law stuff, you have to be admitted to bar. Now, I can understand that to an extent because the state laws do vary. I mean, I think they're pretty much all the same thing, like murder's bad, pretty much everywhere. I don't know how different it is admitted to bar in New York, California, Connecticut, whatever. But medicine is really not like that. I mean, pancreatic cancer is going to do pretty much the same if you're sitting in, state of Washington or Washington, D.C. or Washington Hospital in St. Louis. I mean, it doesn't really matter that much. Your cells don't really have a sense of place. So what are the possibilities of changing that? I mean, states, I assume they want to retain control because they can, and they do, and they will. And state boards are the ones who, determine licensure and so forth. That's a total separate issue about, say, the potential grievances against the board for some of their meretricious actions. I don't know if you want to step and wade into any of that stuff. It's not really a question yet, but.
Well, no, you're right. I mean, you are making an important distinction between doctors and lawyers on one hand and economists on the other. Doctors and lawyers effectively need permission by the state to practice either law or medicine, and an economist does not. That's kind of interesting. I mean, maybe it's because the layperson might require medical or legal help, but does not require the help of an economist. So part of this is a consumer protection regime. You don't have salespeople as economists. And look, so maybe there's some rationale behind that. We do worry about corrupt or genuinely incompetent physicians and doctors and lawyers, but we don't worry about genuinely incompetent economists. They just don't get any business. They don't hurt people. And there is a real, there is a genuine issue here. I mean, we do worry about harmful, incompetent people who are masquerading as professionals. And there is a quality assurance intention behind the licensure regimes. But having said that, even if the intention is to make sure that there aren't any bad doctors or really bad lawyers out there, the bigger question is the regulatory regime that we have the right one? You will have medical societies saying, look, we really take our job very seriously to root out bad doctors. It's our job to make sure that we self-police. And I think there's some logic behind that. I mean, you want physicians to be able to determine what is bad medicine better than, say, a state legislator. But, not only are there self-protection incentives that you have to guard against, but you also have to ask whether or not they're doing a good job. There have been lots of accounts of bad doctors who have been given many allowances by their state medical society. And you see lots of regimes, in particular the one that I was describing, that are keeping out really good doctors from helping local patients. So, even if the intention is admirable, even if the source of these regulatory barriers are well-intentioned and actually maybe did solve particular problems when they were established, we have to be able to look at them with sober eyes and decide whether or not there are better ways to accomplish what they're intended to accomplish.
Understood. So I'm going to segue into some of your other interests and strengths. You mentioned the Rutherford case a little earlier. Can you tell us how that impacts medicine as we know it and treat?
So, the United States versus Rutherford involved some terminally ill patients. I believe they were cancer patients. This is a while ago. And they were terminal patients, and they wanted to try a new drug. And that drug was not approved by the FDA. So the patient said, look, I understand that the FDA has a very important job of keeping out harmful drugs from the market, but we're going to die anyway. At least we're going to die if we do nothing.
Present company excluded. But
what do you mean?
You and I, we're going on forever.
Oh, right, exactly. Yeah, well, right. Yeah, I guess everybody dies eventually, right? But these were terminal patients in the sense that, they can they saw the darkness at the end of the tunnel, you might say.
Yeah.
And therefore they argued that the FDA was transgressing against a constitutional right that they had to try a drug. The question really is whether or not there is embedded in the Constitution an individual right that the FDA was transgressing by disallowing them to try a drug that they really wanted to try. And in what I think is a really good opinion, the Supreme Court did not establish or find or support an individual right to try. And it showed a lot of sympathy for the FDA in disallowing the use of a drug, even for terminally ill patients. The opinion indicated that the FDA has to be very judicious about making sure that patients really know what the consequences are of certain drugs, that drugs that are unstudied or not adequately studied. Was really worried about not only the cost of such drugs, but the possibility of, I guess, the lay person's, or the colloquial way to describe it is false hope. That there's real value in having drugs going through a scrutinizing regulatory process, even recognizing that sometimes that means that drugs that can help people and can save lives will not be ready on time. Ultimately, it was a court that was sympathetic to all of the different weights and interests that the FDA had to balance. And a recognition that if somehow or another the FDA is making real mistakes, that should be addressed through improving the regulatory process and not by introducing a new constitutional right. It's a Supreme Court case. It's not a case that's scrutinizing the value of the regulatory process. The question is whether there's a new constitutional right. And I like the opinion because it recognizes the complexity and the difficulties that the FDA has, even if the FDA is not doing a great job. So I teach the case in my health law course. I'm sympathetic to the case, sympathetic to the outcome. In general, I think that as it relates to health law, when the Supreme Court comes in with a constitutional ruling, it tends to make things worse rather than better. But I also have sympathy for those terminal patients who are really frustrated with FDA lack of speed. I'm trying to think of a better word. Lack of urgency.
Mm-hmm.
And it's a really, really hard policy decision.
Yeah, no, there get to be a lot of I don't know, traffic jams or collisions on that road. We've seen that in the various cases about letting kids die and I'm going to, kind of punt on some of those for now. Are you familiar with Missouri versus Biden and or AB 2098 in California?
Tell me about the court case against Biden.
Well, I think it has to do with. So I'm not an expert on that, but it has to. Missouri versus Biden, I think, is central to. I think it's brought by Eric Schmidt, not the Google guy, but the guy from Missouri, Attorney General at the time, I believe, and it's having to do with the closure of the medical mind in the public sphere. Having state authorities dictate medical decision making en masse. Having kind of a, for want of a better word, having kind of a Soviet style of organized medicine, where the decisions come from up top and everyone else has to just obey. They say jump, you say how high. I could maybe segue and co-research a little bit better. I'm slightly more familiar with AB 2098, which is California, state law proposed, and I guess it's kind of had some court challenges and whatnot. And I think it's going to die on the vine. But that was basically that, they could disbar, for want of a better term, medical doctors in California who did not follow, we'll say, like the Fauci rules, such as propounded by California Public Health. So if they think that everyone should get a vaccine, you don't think everyone should get a vaccine, then you lose your medical license. And there's been kind of this march, downward to have everyone comply. So I'm just curious. I don't know if you waded in on any of these kind of issues about state control of the individual medical patient-doctor relationship.
I mean, so it relates very much to the conversation we had about the Wall Street Journal piece in telemedicine. The difference there, you might say, is that it was the medical society that's establishing rules as an arm of the state, whereas sometimes it's the public health department that's setting up rules as an arm of the state. While we're at it, I'll also, and we mentioned Rutherford as in the role that the Supreme Court plays. In Rutherford, the Supreme Court was deferential to the agency expertise in the FDA. And the FDA, you might say, was trying to navigate the doctor-patient relationship, where really is more the pharmaceutical company-patient relationship. But recently, the Supreme Court has been much less deferential to state bodies and much less deferential to physicians, individual physicians. Certainly, there has been ever since the Dobbs case that has overturned Roe versus Wade, there has been enormous legal scrutiny from attorney generals, from local prosecutors, from state legislators, and from judges into doctor-patient relationships. This is the pervasive theme in health law. Where does authority come from? I would say the foundations of health law in medical malpractice, where we look to community standards, to insurance law, where for the most part we have paid whatever a doctor thinks is medically necessary, to all sorts of individual autonomies, where the patient selects the doctor patient has all sorts of privileges. We've been moving away from that. And in the case of telemedicine, maybe it's a little more complicated in the sense that you have doctors in one state versus doctors in other states. And in that sense, I think it is quite wise to dilute the power or the authority that local medical societies have. But in lots of other regimes, we're not just seeing an intrusion of individual autonomy, individual decision-making, individual judgments of an individual practitioner. We've actually seen the intrusion into societies of physicians. And And, if we want to bring it back to my real bread and butter, the corporatization of American medicine, I think we're seeing that within health systems also, where the corporate powers inside the hospital is shaping how individual physicians want to practice medicine. So we are, I think, seeing a multi-front assault on the autonomy of physicians, on the scientific expertise of physicians. And I think that unless there is some kind of concerted resistance, there will be a real dilution of medical authority, medical autonomy, and frankly, the conversation that we really need among and between scientists to figure out what promotes good health is going to be severely disabled.
Excellent points. There have been flip-flops in medicine. We don't do leeches that much. Well, I mean, it is treatment theoretically for hemochromatosis. People who produce too many red blood cells and whatnot, a polycytosis and so forth. So I mean, it might have a niche, but we don't. But it took a long time to get rid of leeches. And generally speaking, when people didn't do well with leeches, the answer was more leeches. We've had psychological treatments through lobotomies. More benignly, we've had tonsillectomies. I don't know if you're quite old enough, but in my era, everybody got a tonsillectomy, and I think it was, they could have just renamed it ENT College Fund. ENT's Offspring's College Fund, because everybody, we got ice cream and whatnot. I still have mine, but my wife doesn't. But everyone had them taken out. They're very useful function. They're lymph glands, and they act as guardians at the gate. And they were killed off. But it was very lucrative, and took a long time before people said, this was really. Anyway, but now we have, without wading too deep into the culture wars, we have kind of legalized castrations. For a long time, I guess in the 80s and 90s, doctors here, looked down on Egypt with its clitoridectomies, the removal of the clitoris, for social mores, as barbaric, and yet we've really gone much further than that. We are doing mastectomies in pre-pubertal, pubertal, post-pubertal, whatever, young girls, before the age of majority, and all the different types of effective castration as far as reproductive, under the rubric of a kind of a diffuse gender dysphoria diagnosis, which is supposed to be adequate, bad enough sounding to get the insurance companies to pay, but nice enough that the people who have it don't feel as if they have a disease. Anyway, that's a long intro. As far as what happens with this kind of corporatization or lockstep aspect of medicine, people who speak out against that, and we've seen what happens in the social media world. But I think the same thing is happening in the medical world as well. Certainly, it happens in the NHS in England. Are we moving towards kind of this uniform, party, authority, whatever aspect of treating medicine, where we are, I guess, in a sense, socialized?
I mean, so I would put the problem a little differently. There is, of course, a big distinction between mass castration and selective treatments, where you have individuals trying to address individual problems. It's certainly different from also having, as a standard of care, making sure that everybody has tonsillectomies. I remember that, by the way. I think I barely escaped that regime by maybe a couple of years. And look, I mean, at the risk of being, just stating the obvious, there is a tension between recognizing variation in medicine because the science is imperfect, or recognizing variation because patients are different, versus establishing some kind of uniform standard because either science or morality really requires it. I mean, I think in all of those cases, you don't get a standard without some kind of scientific and social moral consensus. And sometimes those scientific and social moral consensus are things that we're very proud of. You know, I mean, I was going to say vaccinations, but even that, you know, has a lot of resistance too. So I don't even know what we could say. Really, everybody does now. And sometimes, though, those scientific and moral consensuses are embarrassments in history. I mean, I think that, and I think you would agree with this, we want to welcome variation, and also we want to welcome the incorporation of consensus, so long as it's done in a really sober, scientifically minded way. That's, of course, not what's happening at all. We have ideological imperialism in a lot of fronts. A lot of it is baked on certain misconceptions. A lot of it is baked on certain religious or ideological beliefs that are not uniformly held in the country. And look, I mean, to a large degree, if we're going to have thoughtful dialogue, if we're going to have a scientific discussion that really advances the body of knowledge, we have to change the way we're talking about things.
Yeah, it's tough. Is there hope for the individual physician as an independent voice? I'll just give one example. I had on just the other day Mary Talley Bowden. She's an ENT in the Houston area, I believe, and she was seeing a lot of sinus stuff and upper respiratory during COVID, and she was prescribing ivermectin, and the Texas Medical Board has gone after her to remove her license and all this kind of stuff, and she's fighting. The FDA, I guess she's got a case against the FDA. The FDA has recently been reprimanded for having had its own kind of ad campaign calling ivermectin a horse dewormer. Now, it's an FDA-approved medication for humans, and as much as some of us may look like horses or act like a horse's posterior from time to time, we are not genuinely equine, and so HCQ as well. It's psoriatic arthritis, that kind of stuff. These are FDA-approved medications. There's been long-term use. I think it's OLDU, off-label drug use. Can you? I don't know if you want to wade in again.
Yeah, I mean, I'll say this. Like, I mean, I have no doubt that drugs that are approved for human use by the FDA can be used with a certain degree of efficaciousness in some patients. There's no question about that. And that's why we allow off-label use within reason. That's why we even pay for off-label use. And that's why the standard of medicine guidelines tend to be fairly flexible. We recognize that once somebody becomes a physician and is licensed by the state, there's a certain degree of wisdom that every licensed physician has, maybe almost every, and we allow the practice of medicine with a lot of discretion. I mean, the FDA says these are the drugs we think are okay, but the FDA always says we don't tell doctors how to practice medicine. There is a difference, however, between recognizing that physicians have discretion and recognizing that drugs, including ivermectin, can be efficacious in some patients some of the time, and managing a pandemic where there is a certain degree of behavioral anxiety that can be really destructive to population health. I mean, to make it simply, it's different between when a doctor and a patient are having a conversation about what to do with the patient versus the CDC making an announcement saying everybody needs to do this, otherwise we're going to have thousands and thousands of people unnecessarily dead. The former is practicing medicine. The second is instituting public health measures. Mm-hmm. And look, there's just a difference between the two. It's one thing for a physician to say, look, I think in these circumstances, ivermectin is really good for you. It's another thing for a physician, and I'm not saying this is what happened in your circumstance, for a physician to go on Twitter and say everybody should be getting ivermectin to deal with COVID. I mean, there's a difference. And look, I mean, if you are in a public position, say you are in the medical board and it's your job to police physicians, you're in a tough spot because on one hand, ivermectin, I believe you, I'm not the physician, ivermectin can be useful in some circumstances for some people, but you also are navigating a social health crisis where you want to direct individuals to behaviors and to regimens that tend to be better than others. So when you are releasing health information, this is also one problem we have with the science of diets, the science of nutrition, where there's always a fad coming in and out, and the truth in a population sense is really hard to hammer down. We have different standards, and those are hard to navigate. So with that distinction drawn, I have no doubt that there are lots of people who are good physicians who are prescribing ivermectin. I have no doubt that there are some of those are being unnecessarily criticized. But I also have a lot of sympathy for our public health leaders when they're navigating a crisis, and there's lots of genuine misinformation out there coming from all sides. And I'll reiterate what I said before. It's really hard to navigate those things when people are not speaking soberly and respectfully and speaking in the language of science.
Right. Fair enough. I think it's actually, I think the we'll call it crimes with a small c, peccadillos, what are committed by many different aspects. I think that public health was on very tenuous, shaky ground. Insofar as lockdowns had never, I mean, the term lockdown is a prison term. It's only been used in prison populations with two exceptions that I could find in the literature. One was a leper colony, basically in South Africa, and the other was for a couple days in the face of Ebola in
although, sometimes it works the other way too. Sometimes actual lockdowns or imprisonments are called detainments. We're just going to detain you for a little while. So, we after September 11th, all these detainees. Language means something, but it also is very flexible.
I understand, but the lockdown was actually for prisons. That was when there was rioting within a prison. We're going to lock down the entire population. The lockdown is when you take everybody. You punish, exclude, whatever. You restrict everybody on the basis of an actions of very few, or
maybe they called it shelter in place instead. I don't know.
Oh, whatever. We're going to leave that aside. But I think a lot of that, we found, and I'm not here to debate that or litigate that. So what are the challenges you see, greatest on the horizon for physicians and medical care in general?
Yeah, no, and I'll just say I don't mean to litigate what the CDC did or should have done, and I have no doubt that there were lots of bad decisions from top to bottom. But I mean, moving forward, we kind of have to have, you might say that the medical world and the political world have some common healing to do. There's got to be some restoration of civic disagreement. And, again, I don't really work in the political world of shelter in places or mask mandates or anything. I work in the delivery of care framework of the hospital system. And even there, if we're talking about language, there are there's lots of room for improvement in what kind of language we use. Central administrators often use disparaging terms for physicians and especially for nurses. Nurses and others and physicians use disparaging terms for the people who are making managerial and strategic decisions. everybody makes disparaging terms about insurers and PBMs. I mean, you might say actually that the one common feature of healthcare policy is that every actor says that there's another actor that's doing worse things than they are.
I literally have had narcotic dealers. I had a regular medical practice for about 30 years, and I had my own office. And over the time, I started doing a Suboxone-oriented detox over multiple months. And so I had, interesting population cohort. And when I oftentimes had, big heroin dealers come through, not every day, but a few times per year, they always basically, excuse themselves because somebody else would be doing that, but for them. If you say, you get rid of me, you put me in jail, guess what? Heroin's still going to be in the streets. It's going to be somebody else just like me doing this. So what's the difference? Anyway, that's a total separate thing.
It's separate, but I see why it triggered that memory. I get that. And look, I mean, we're not going to solve the problems of the healthcare system if we only address misbehavior by physicians or misbehavior by PBMs or misbehavior by hospital systems or by insurers. We really have to recognize the systemic problems. We've got to recognize that meaningful reform is going to require changes in each of those markets. And to the degree that I would say political rhetoric or even frankly constitutional law can stay in its lane, to the degree that we can really talk about this through the language of problem solvers, I think that would be beneficial.
Okay, so before we go and let you get back to economizing, you had an article on the Rooney Rule. Maybe tell us a little bit, I mean, as you can kind of say what the Rooney Rule is and how it related to your discussion in law.
Yeah, so, I will say at the outset that there's a sentence, maybe even a paragraph, I think a full paragraph in that article saying that the real Rooney Rule may not be working.
You do mention that.
I'm not endorsing the Rooney Rule. So this is the story. So what is the Rooney Rule? The Rooney Rule, the NFL recognizes that about 3/4 of the players are African-American and very few coaches are African-American, especially head coaches.
So what they proposed to do was add more white players, right?
So they wanted to see if there was a meritocracy in both markets. And there was a sense that one reason that there weren't many African-American coaches is because there weren't many African-American coaches being interviewed for head coach jobs. That was a sense of what the problem was. And one solution was to require African-Americans to be interviewed in any head coaching job. So that's the Rooney Rule. Lots of people think that it's done good things. Lots of people think it's done bad things or hasn't worked. I really don't have an opinion on that. What I am responding to, or what the article is about antitrust cases. In particular, antitrust cases involving the healthcare sector. Although I also talked about the AT&T Time Warner merger. And this is the simple problem. Antitrust law is supposed to help the market. It's supposed to be informed by economic science. But a lot of antitrust cases, or in particular judges sitting in antitrust cases, either don't apply economics or don't understand the economics that experts are presenting before them. So we can't fire the judges, nor should we. But what we can and should do is figure out a way for judges sitting in antitrust cases to understand the underlying economics better. And look, these judges are judges not because they're economists, they're judges because they're lawyers. And frankly, they're probably appointed to being judges not because they're antitrust judges, but because they were really good at voting rights cases or constitutional cases or whatever. So I propose something that I think is kind of modest, which is that when a judge is assigned an antitrust case, they should at least talk to an economist. They don't need to hire an economist to be a special master, although they could. They at least have to, outside of the economists that are presented by the parties, should consult with somebody that might give them a better perspective on the matter before them. I'm presuming that judges want to do the right thing. I'm presuming that judges want to apply antitrust law as it's supposed to be applied. I'm just simply saying that maybe judges should consult some economists if in fact they're ruling something that relies on economics to come to the right ruling. It's just like if an oncologist has a patient that for whatever reason requires a consult with an orthopedist, I'm making things up, they wouldn't just say, well, I'm a doctor, I know enough. They would say, look, I'm going to consult with somebody who knows something about this particular area that should inform my judgment. By and large, judges don't do that. So the subheading of the article is, it's okay to ask for help.
Yeah, no, I like that. I mean, cynically, and take no offense, please, we could also call it the Economist Full Employment Act. And then, of course, there were a couple of things that when you said economic science, I'm sure some people will snicker as a potential oxymoron. And then, of course, then there's the issue of which economist you're getting. With football coaches, I think you're getting somebody who, say, literally knows X's and O's and is directed, and they have an actual score. They can grade football coaches by wins and losses. Where economists, you have, in my view, you have somebody like Paul Krugman, this called the Krugman effect, which is you should always bet and put your money at the opposite of what he says. And say along the lines of more my favorite, Milton Friedman and or Thomas Sowell. You're getting a wide brew potentially. You can have an interesting batch or whatever, and so it's a tough point. And then, of course, what is an economist, etc. We in medicine have our own interesting points, like these days, what is a woman and what is this, what is that. We kind of touched on those a little bit earlier. Anyway, thank you for all of this.
One final comment. Milton Friedman was a genius economist. Paul Krugman is a genius economist. Both of them are fairly good op-ed writers. But we want to distinguish between their academic contributions and their armchair philosophizing.
Right. Yeah, no, that's a tough thing. And actually Sowell says, and I'm not going to get the quote right on the top of my head, but basically, the professions where people aren't graded for their actual work only leads to poor work. And a lot of these things are fluffy because unlike football, one of the things I like about watching sports is that ostensibly there's a score and you can pretty much decide who was in bounds, who was not. There's disputes about, the two toes and whatever, and was he, bobbled the ball. There's micro managing of these things. You got red flags, but at the end of the day, somebody won and lost. Whereas, many things in the world of economics, people don't even necessarily agree on what are the reasonable outcomes.
Well, that's true. Although I will say that both Friedman and Krugman got the Nobel Prize because their theories were supported by abundant empirical tests. You don't get the Nobel Prize if you're not actually advancing empirically supported science.
Well, fair enough. I do think
but when you write an op-ed, you don't have a large data set.
Yeah, the Nobel is pretty good. I interviewed recently Dr. Barry Marshall, who won the Nobel in, I think, 2005. And he's the guy who basically, he and Robin Warren pointed out that ulcers, which had long been thought to be stress and diet, were in fact a bacterium. And, basically cured the peptic ulcer. That has a scorecard, that's shown up. It's an interesting phenomenon. I haven't really followed the Nobels in economics, but sometimes, even the Peace Prize, whatever, one man's peace winner is another man's, not. Anyway, I hope you get one.
I'm happy just having a job, and I enjoy conversations like this, Randy. Thanks for having me on again.
Thank you so much. I really appreciate it, and have a great day.
Thanks, man.